very interesting roundtable, another very interesting session concerning the implementation of the ECJ's judgment at the national level. So we will discuss how the national courts have applied the two-step test. Before the break, during the great dialogue among our excellent practitioners, we have already had an idea about the difficulties and the challenges that the application of the two-step test defined by the Court of Justice can raise. And so now we will see how the national courts have applied the two-step test. And I'm very eager to know and to see, thanks to our speakers, how the court have implemented this test, particularly the second phase, the second step of the test, which is particularly challenging, not only because it is the decisive phase of the test, but also because it raises a lot of issues. And so today's first speaker is Alessandro Rosano. Alessandro Rosano is a postdoctoral researcher of EU law at the University of Florence, and Alessandro will describe us how Irish and the UK courts have applied the LM judgment and the LM test. And let me say that it is not a coincidence that we're starting with the Irish case law, because as Professor Torres Perez has already mentioned, the LM judgment originated from a request for a preliminary ruling issued by the High Court of Ireland. And so Alessandro will give us the background of the LM judgment, but also its direct follow-up and its further development. So Alessandro, you have the floor, and you have 15 minutes.
Okay, good afternoon. Thank you very much for inviting me. It's a pleasure to be here. Thank you to the organizers, and especially to Nicola, Zerini, and Marcella. Thanks to all of you for being here. Now, I'd like to tell you something about what happened in Ireland and the UK after the LM judgment, and how the LM test has been applied so far by Irish and UK courts. Well, for what concerns Ireland, let me remind you that the EAW implementation legislation does provide for a ground for refusal of recognition and execution related to the protection of fundamental rights. As a matter of fact, under Section 37 of the European Arrest Warrant Act, a person should not be surrendered if the surrender will go against the European Convention on Human Rights, the protocols to the European Convention on Human Rights, or the Irish Constitution. Again, if the surrender would expose that person to some forms of discrimination, if the person will be sentenced to death, or a death sentence will be carried out, or if the person will be tortured or subjected to inhuman or degrading treatment. This section is based on recital 12 of the EAW framework decision, but it must be said that in 2007, the European Commission suggested that Section 37 goes further than any other comparable member state implementation measure. It goes beyond the actual text of the framework decision. Thus, it gives rise to an incorrect implementation of the framework decision. And by the way, Italy was criticized for very similar reasons. However, infringement proceedings could not be brought by the European Commission in the realm of the former third pillar, as you probably remember. That being said, notwithstanding the express inclusion of Section 37 into the implementation legislation, the Irish Supreme Court seems to have rejected all the challenges on fundamental rights grounds in surrender proceedings. Thus, the relevance and the utility of Section 37 could be called into question. For instance, in Brennan, the Irish Supreme Court held that some egregious circumstances, such as a clearly established and fundamental defect in the system of justice in the issuing member state, would warrant a refusal of surrender pursuant to Section 37. but in that case, the appeal was dismissed, and the line of reasoning was confirmed in other cases, such as Stapleton. Before focusing on LM, let me just recall that before the ECJ came up with the LM test, the Irish Supreme Court had already developed a similar tool that happened in Rettinger. In Rettinger, interpreting Section 37, the Irish Supreme Court held that in surrender proceedings, a court should consider all the material before it, and if necessary, material obtained of its own motion. It should examine whether there is a real risk. It should examine the foreseeable consequences of sending a person to the requesting state, and it should take into consideration reports of independent international and human rights organizations. Now, focusing on LM, we all know that Poland sought the surrender of Artur Selmer for the purposes of prosecuting him for several drug trafficking offenses, and Mr. Selmer objected that his rights under Article 3, 6, and 8 of the European Convention on Human Rights would be violated should he be surrendered. The objections related to Article 3 and Article 8 were dismissed. For what concerns Article 6, the right to a fair trial, Mr. Selmer relied on the reasoned proposal of the European Commission of 20th December 2017, meaning the proposal for a Council decision on the determination of a clear risk of a serious breach of the rule of law in Poland. Thus, reference was made to the ECJ for a preliminary ruling in order to understand whether the Aranyoshan-Kaldaravi test would apply to a possible violation of the right to fair trial, and as we all know, the ECJ replied in the affirmative. So in December number 4, the High Court Dublin tried to apply the test to the actual case. As far as the first step, the High Court held that the reasoned proposal amounted to specific, updated, objective, and reliable information as to the situation regarding the threat to the rule of law in Poland. By the way, the High Court, in its decision, the High Court referred not only to the reasoned proposal, but also to opinions issued by the Venice Commission of the Council of Europe. As far as the second step, well, specific and precise assessment was needed. According to the High Court, it was necessary to seek further information from the issuing judicial authority to assess the real risk to Mr. Selmer of breach of his fundamental right. Well, in December number 5, the High Court referred to the information it had obtained. The president of the Warsaw Regional Court had replied to that request for information, and she stated that there had actually been dispute about the constitutionality of the changes, but in her opinion, those changes were consistent with the Polish constitution. She believed that Polish law provided for guarantees of independence for judges. She believed that there was no risk of a violation of the right of fair trial. Warsaw Regional Court judge replied to, well, actually, he believed that there were some issues related to the independence of Polish judges. He referred that some judges had been summoned for disciplinary proceedings arising from politically controversial rulings. However, in his opinion, Polish judges were trying their best to perform their obligations. In the light of this, the High Court ruled in favor of the surrender, holding that notwithstanding the reference to the guarantees depending on the person judging the case, there has been no production of statistics or even anecdotal evidence of trials lacking in fairness since the changes regarding the judiciary in Poland. Moreover, it has never been suggested that the fair trial rights have in any way been affected. Considering the importance of the case, Mr. Selmer was granted leave to appeal against that decision, and in its Selmer judgment, the Irish Supreme Court confirmed how relevant the second step of the LM test is. The Irish Supreme Court stressed that it is necessary to show specifically and precisely that there are substantial grounds for believing that following the surrender, the requested person will run the risk in fact. And with a wording quite similar to the one used by the High Court in its judgment, the Supreme Court confirmed that there was no evidence, even anecdotal, suggesting such changes had affected the hearing or determination of charges generally, and there was no evidence of the impact of any of the criticized changes upon the trials conducted in any of the three regional courts involved, meaning the three Polish courts that had issued the European arrest warrants. So it looked like how can I say, it looked like Mr. Selman had overstayed his welcome in Ireland. So bye-bye, Mr. Selman. And since then, the summary judgment of the Supreme Court has become the point of reference for the High Court as the competent executing judicial authority. And over time, objections related to the legislative changes in Poland have been dismissed for similar reasons. For instance, in Dariusz Florczak, the defense relied on a report drawn up by a Polish Judges Association, but the High Court had that no evidence concerning any specific risk or prejudice which the respondent was likely to suffer had been provided. And something similar happened in Jakub Liszkiewicz and in Rafał Łukazik. In these cases, the defense relied on reports submitted by Polish lawyers, but the High Court had that nowhere in those reports did the lawyers identify any particular feature of the respondent's circumstances or any particular feature of the proceedings involving the respondent, which would indicate a particular risk for the respondent. And similar reasoning may be found in Tomasz Latek and Wojciech Orlowski. Moving to the UK case law, well, decisions that have been taken so far are quite similar. The objections related to the legislative reforms passed in Poland have been dismissed for reasons related not to the first step of the test, but to the second one. Actually, for what concerns the first step in Lis, Lange, and Chmielewski, the England and Wales High Court held that there should be no need for expert evidence of a general nature to be adduced in Polish surrender proceedings. And why is that? Well, because the resolution of Article 7 TU process is still pending. So the relevant matters are sufficiently explored in materials available in the public domain, and in particular in those generated in that process, which means that the reasoned proposal issued by the European Commission is more than enough in this regard. For what concerns the second step, UK courts had that there was no individual risk related to the possible violation of the right of fair trial, or better, no decisive evidence had been provided. So in conclusion, what can I say? Well, analyzing these judgments, it looks like Irish and UK courts have been looking for statistical certainty. Maybe they do not want the smoking gun, but they want to know how likely it is that there is a smoking gun, and that must be very, very likely. The standard of proof is very high, and in none of these cases it has been reached, not even in a Circuit Court of Warszawa Praga against Patrick Michał Maciejec. In this case, the defense relied on some expert witnesses, two Polish lawyers and Professor Laurent Pech, who is one of the leading experts in the field of the rule of law crisis in the European Union. They stated that the judicial appointments in Poland are made on a political basis. They stated that there is no effective mechanism to protect the independence of judges, and they stated that the new disciplinary system created, and I quote, a climate of fear. According to the Sheriff Court of Lothian and Borders, these aspects are related to the first step of the test and are relevant in that regard, but they are not related to the second step. So the evidence was not impressive, and there was no buzz to surrender. So I think that this is becoming some sort of probatio diabolica, as it has already been said this afternoon. That's it. That's what I wanted to tell you. Thank you very much for your attention, and again, thank you very much for inviting me here.
Thank you very much, Alessandro, for your very rich presentation. And so let me stress that as you have highlighted, both the UK and the Irish court put a great emphasis on the second step, on the necessity of the second step of the test. So they highlighted that the findings of generalized or systemic deficiency are not enough, and it is necessary to show that those deficiencies effectively affect the court before which the requested person would be tried. So the analysis of the UK and Irish national case law gives the impression that those courts have taken a very narrow approach vis-à-vis the test. They conceive the test in a very stringent way, and so they admit the refusal to execute the European arrest warrant only in very exceptional cases and circumstances. And thank you also for stressing another very interesting point concerning the implementation of the second phase of the test, namely the sources on which the national courts base their decision. And as you have mentioned, the Irish courts referred not only to information requested to the issuing national authorities, but also to the expert reports. So they request some legal expert in Polish issues and Polish legal system to make a report, and these experts were also examined by the Irish court. So it is very important to consider also the sources on which the courts based their own decisions. And thank you also for referring to another very challenging element which has already raised during the dialogue, namely the burden of proof, which I think will be the fil rouge of your presentations. So now we move to another member state, the Netherlands. And the case law of the Netherlands will be presented by Adriano Martufi. Adriano is assistant professor of criminal law at the Leiden University, and I would say that also in this case the order, the sequence of our speakers is not a coincidence, because Adriano will give us the background and the follow-up of another leading judgment of the Court of Justice, namely the L&P judgment, which originated from two actually preliminary requests for preliminary rulings raised by the Court of Amsterdam. So Adriano, you have the floor.
Thank you very much, Marcella, and thank you so much, Nicole, for this very kind invitation. I'm very happy to be here today to join this very interesting discussion, I must say. So I'm going to say a few words about what happened after LNP, but before that, I would also like to say a few words about the Dutch case law previous to that preliminary ruling. And so, I will begin by setting the scene with a few words about the Dutch case law and the case law of the Court of Amsterdam. And in the second part of my talk, I will present how the follow-up to this decision was handled by the Court of Amsterdam, which is the exclusive executing authority for the Netherlands when it comes to the European arrest warrant. So to begin with, what was the background to my preliminary reference, to the preliminary reference in L&P? So I'm not gonna share the slides, but of course, if any of you needs the references to the cases I'll be mentioning, do not hesitate, I can provide them to you. And I'm gonna base myself on an article a colleague of mine and myself published last year in July, just a few weeks before the Court of Amsterdam actually issued its preliminary reference to the Court of Justice. And in that article, we actually compared the use of the Aragnosi test with the interpretation that the Court of Amsterdam gave to the LM test. And that comparison was actually pretty instructive, I must say, because I mean, what came out of that analysis was in fact that while we had dozens of cases where the Court of Amsterdam had refused surrender for on grounds of risk of human and degrading treatment, mostly related to prison conditions in several member states of the EU. There were no cases, so we were at least unable to find any single case where the Court of Amsterdam refused surrender on grounds of a risk of violation of the right to a fair trial on the basis of the LM test. So that was already pretty significant, I must say, and we covered a significant amount of cases in our research. And the second relevant finding that we came up with in that article was that in applying the LM test, the Court of Amsterdam actually follows a 3-pronged test and not a 2-pronged test, which at first sight might look a little bit odd, but actually with a closer inspection, it turns out to be a very close reading of the LM test. Actually, and that this confirms, I'm going to say a few words about that in a minute, but that confirms that the LM test and the Aragnosi test are quite different, both substantially but also formally. And I can say a few words about that later in our discussion, if you like. So at least as of October 2018, the LM test is interpreted by the Court of Amsterdam as a 3-step test. So the first step is of course, the analysis, the finding of systemic and generalized deficiency having to do with the right to a fair trial. And so that's in line with the traditional description of these tests. The second step of these tests, however, is where the Court of Amsterdam, where the executing authority analyzes the impact of this systemic deficiency on the court system. And that second step actually builds on paragraph 74 of the decision of the ECJ's decision in LM, where the court actually mentions the need that this deficiency might have an impact on the courts having jurisdiction over the proceedings involving the requested person. And actually, what the Court of Amsterdam does is basically to single out this part of the test to make it a self-standing, autonomous element of its exercise. And then, of course, the third step is the individual assessment. And so the assessment of the circumstances that may lead to conclude that the person concerned and their right to an independent tribunal will be affected in case of surrender. Now, without entering too much into detail, I'm going to say what is characteristic about the way the Court of Amsterdam handles these cases is that essentially, instead of having each time, so in each decision, a case-by-case assessment of all these different steps of the test, the court tends to rely on general assumption based on its previous judgments. So it may actually end up presuming one or more steps of the test. And this happens quite frequently, and actually it happened very soon, almost a few months after the case of LM, by presuming step 1 on the basis of a number of sources of information. Some of them are very similar to those that Alessandro mentioned as well. But basically, as of that time, so when the court, because we are talking about an exclusive executing authority, so we don't have a plurality of authorities. So that's very handy for them to basically rely and build on previous judgments that they made. So they basically take step 1 as a given, and they do not come back to the finding of systemic deficiency in each judgment. And then step 2, which is, like I said, is the impact on the court system, which is more, if you like, case sensitive. And for that reason, as the Court of Justice itself has requested in LM and then in LNP, the Court of Amsterdam may engage in a dialogue with the issuing authority to obtain the necessary information. And in this case, when this happens, when these requests of information are made, and of course, this information may also have to do with the third step, the surrender proceeding is suspended, and this may take months. And actually, usually, when this is suspended for an indefinite time. So there's of course a clear derogation here to the time limits provided for by the framework decision. And so for a certain period of time between 2008 and until 2009, the Court of Amsterdam has asked numerous questions to, especially to Polish judges, so all the cases we have actually concern Poland, to verify the impact on the courts, and especially on the courts having jurisdictions on the criminal proceedings involving the requested person. And these questions were extremely detailed, I would say, encompassing questions about the staff of the courts with jurisdiction, and so questions like the retirement or possibly the demotion of judges, the internal organizations of those courts, the way they handle cases, the system of appeals against the decisions, and so on. So a long list of decisions until in September 2019, also in light of the recent opinion by the European Commission in the context of the infringement procedure against Poland, these requirement, the verification of this requirement also became implicit. So from that moment on, the Court of Amsterdam basically concluded that the deficiencies having to do with the rule of law backsliding were so evident that they by all means impacted the court system. So there was no need to demonstrate that impact on a case-by-case basis. But then, of course, it remained the third step. So the verification, the individual assessment, that the impact on the courts will also be relevant, will also translate into an interference, an impact into the person's right to an independent tribunal. So, like I said, this is a third and separate and distinguished exercise, and that remained to be demonstrated. And that is, of course, the crux of the problem, and the difficulty to obtain information, of course, from the parties. The surrender proceedings in the Netherlands are very adversarial, so both parties can provide information, both the defense lawyers and the prosecutors. But of course, most of the time, relevant information in order to refuse surrender might come from the defense lawyer. But the difficulties that we've been discussing several times today for the defense lawyers to provide specific information to conduct the individual assessment, of course, were a major stumbling block. And I guess we could say that this major stumbling block, although in many cases actually had as a result that the requested person were in fact surrendered to Poland, was actually the main reason the Court of Amsterdam raised its preliminary request in LNP in the two cases. And so we know, and you all know very well about this case, so I'm not going to say anything about that, but I'm going to just say a few words about what happened after that case. And you're probably going to be disappointed, because the thing is, and so the spoiler of my conclusion is that the assessment framework that I described so far didn't change that much after LNP, as one might expect. So if before LNP, the court, in at least several cases, but I can mention one of them in January 2020 actually allowed the surrender because of the lack of specific information meeting the requirement of the individual assessment. After L and P, it only allowed to get to a different conclusion in a single case. So I, myself, and my colleagues involved in similar research projects in the Netherlands were only able to find one single case where the Court of Amsterdam actually refused surrender to Poland, and that's the case of L. So one of the two suspects and the requested persons in the two proceedings from which the preliminary references originated, and not both of them, but in only one of the two cases, so the case of L, the Court of Amsterdam actually concluded that the surrender had to be refused. But it came to these conclusions on very specific grounds that, like I should say, do not set a very encouraging precedent. So some of the speakers previously mentioned the Netherlands and the Court of Amsterdam as one of the courts that very boldly took a stance and refused to surrender to Poland. But that happened, as I shall say, in a very, very specific set of circumstances that are very hard to be replicated. And that's because, essentially, on the one hand, the court conceded, and so that's a very general concession that might lead you to think that, yeah, that indeed they are skipping the individual assessment, because they concede that the judicial reforms, the legislative reforms in Poland, and especially the ongoing activity of the disciplinary chambers of the Supreme Court have, like they say, a chilling effect affecting all Polish judges. But despite this general finding, they go on to demonstrate the existence of a risk in the individual case. So they do not skip the third step or the second step, as you prefer, of the test altogether. They actually conduct this test very accurately, and they come to the conclusion that the surrender needs to be refused. First of all, because in light of the information available to the court, which were not provided to the court by the defense lawyer, surprisingly enough, it appeared that several judges of the competent courts in Poland, so the regional court of Poznań, were actually targeted by disciplinary proceedings as of 2019. So that was the first reason. And the second reason is that the outcry generated by the suspension of the proceeding in the Netherlands and the reference to the Court of Justice in Poland and in the Polish media made appear the suspect in that proceeding, Mr. L, as the court said, not as a random Polish suspect, and I'm quoting the Court of Amsterdam, but as a person that had come under the special, or had become the subject of a special attention from Polish authorities. So that's the significant shift that may affect the fairness of the proceeding in his case. And finally, and perhaps more significantly, the name of the suspect, so the Mr. L, was mentioned in a memo issued by the prosecutor's office, the National Prosecutor's Office in Poland, concerning surrenders to the Netherlands. So a memo recommending Polish public prosecutors to halt or suspend all requests of surrender in the context of EAW proceedings to the Netherlands. And that memo mentioned Mr. L by name. And so because of all these circumstances that, like I said, are very hard to be replicated, the court came to the conclusion that surrender of Mr. L had to be denied, had to be refused. So I would stop here for now. I'll gladly take some of your questions later on. But that's, the main takeaway message of my presentation is that despite this very bold decision, these circumstances and these conditions under which it happened are very, very hard to happen again under the current legal framework. Thank you so much.
Thank you, Adriano, for this very rich and comprehensive presentation. You stressed several interesting points. It's difficult to wrap up because you really emphasized some very critical aspects of this case law. So first of all, let me stress the reference you made to the duty to cooperation. Actually, we have already mentioned that one of the most critical and challenging aspect of the second step is the fact that in LM, the Court of Justice put a great emphasis on the duty of cooperation between the national authorities involved. And I found very interesting the references you made to the way in which the Court of Amsterdam has applied and interpreted this duty of cooperation, making very specific and comprehensive questions to the court to the Polish authorities and the issuing national authorities. But I find very surprising the follow-up of the L&P judgment. So thank you for stressing this follow-up because it confirms my first impression. So the fact that actually also very open court like the Court of Amsterdam, which is on the front line in this field, actually take a very restrictive approach. So put a great emphasis on the second step. So the fact that the impact of the findings of generalized and systemic deficiencies must be proved in a very specific and concrete detail. So you thank you very much for stressing the occurrence and the concrete way in which the Court of Amsterdam applied this second test, second phase of the test, and as a matter of fact, it decided to refuse the execution of the European arrest warrant just in one of the two cases. So thank you, and now we move to another very rich national case law, the German case law, which will be presented by our next speakers. Who are Carolina Postador, a lecturer in European law at the University of Maastricht, and Rebecca Spetti, research assistant at the University of Maastricht as well. So thank you. Okay, you are already presenting. Perfect. So Carolina and Roberta, you have the floor.
Thank you so much. Sorry, just need to manage things a little bit. Thank you very much. Thank you for the invitation. I mean, we do represent Trial Project University of Maastricht here, so there's one person missing from our research team here. Today, I mean, our mandate was to present the German jurisprudence on European arrest warrant. So we are going to speak about the, of course, but we are also wanting to take our discussion perhaps also towards other issues that have been raised in the jurisprudence of the Court of Justice of the European Union and in the national German case law. So in fact, we chose to showcase two judgments. First of all, we're looking at the application of LM judgment to the to a Polish arrest warrant. That case was decided by the High Regional Court in Karlsruhe, so you will hear the abbreviation HRC every now and then here. It is an interesting case because it was a case that was decided before the LNP judgment, and it basically showcases yet another strategy, albeit somewhat similar to the ones that you have already described in the Dutch and the Irish and the UK context of dealing with the LM test. And the second judgment that we would like to discuss with you is the evaluation, or the request for the evaluation of the position of the Public Prosecutor's Office and the series of judgments that were related to such an evaluation in the light of Article 6 of the Framework Decision. Of course, in both cases, we are asking implicitly a question whether this implementation of the Court of Justice judgments is an appropriate one, or perhaps it adds something to our discussion or subtracts something from the discussions that we're running. And in both cases, we actually are looking at the quite dense context of judicial interaction techniques. I'm putting this concept on the table here as a guiding concept in our project. Also, there's a concept that sort of emphasizes this multidimensionality of the discussions that the courts and judges engage themselves in at the moment. So, of course, in our implementation of an LM test case, the tribunal of the Karlsruhe is yet another tribunal and yet another court in the context of this whole family of case law, in fact, that is trying to make sense of this whole story, of course, especially in given the events and ongoing events in the Polish setting. And here we can see that aside from the LM, I mean, the court is actually very richly influenced by the national case law. So just as Adriano was mentioning, that it was the Amsterdam court that has developed its own way, its own strategy of dealing with LM, so did the German courts, and this strategy is visible in this case as well. Secondly, for the evaluation of the position of the issuing judicial authority, I mean, here we have a series of cases, both on the international, on the European Union level. First, the two that were evaluating German prosecutors, so OG and PI, and the second that is evaluating the position of the Prosecutor General of Lithuania, the case PF. And then we see that on the basis, or as a follow-up to those cases, a national court, this time in Berlin, actually tries to evaluate and see how to treat the position of the Austrian prosecutors, and to that effect also files a request for the preliminary ruling to the Court of Justice of the European Union. So I have given you a little bit the context of why we've chosen those cases and how we look at them here. And Rebecca, our junior researcher in a trial project, will walk you through the facts of the case and the specific reasoning in both of those cases. So Rebecca, over to you.
Thank you very much, Carolina. Good afternoon, everyone. It's really an honor and pleasure for me to be here. First, I will present this judgment, which is a landmark judgment for a number of reasons. While the Higher Regional Court of Karlsruhe initially accepted that the changes at the supreme level of the Polish judiciary, including the introduction of the exceptional appeal, have not affected the capabilities of the ordinary courts to decide on criminal cases in an independent, impartial manner, this changed because the deterioration of the rule of law, however, that occurred after the so-called Mazur law, which entered into force in February 2020, was the turning point for the Higher Regional Court. This law led to a tightening of the disciplinary responsibility of judges, also at the ordinary court level. Indeed, this ruling is groundbreaking for a number of reasons. First of all, because it was the first time a German court refused to release the Polish citizens to the Polish authority as mandated by the European arrest warrant. It found, indeed, an individualized risk in accordance with the second prong of the LM test, and it demanded more information about the current situation in Poland, but surprisingly, it did not wait for the response by the Polish authorities, asserting that the answers would not have changed the legal assessment, namely the rule of law crisis and the guarantees of judicial independence under danger. With regard to the facts of the case, it's pretty straightforward. The applicant was a Polish national who an extradition warrant has been issued against. He was in extradition for the purpose of criminal prosecution, being accused of fraud, and he agreed to a simplified extradition procedure at his judicial hearing before the local court in Germany. He denied all charges brought against him by the Polish judicial authority, and he added that 2 influential Polish nationals had allegedly been bribed into making false statements, additionally beating him up. He has now been living in Germany with his partners since 3 years. And while the HRC initially declared the extradition admissible and rejected the application of the prosecuted person for the revocation or suspension of the extradition warrant, it decided, after an analysis of the situation in Poland, in light of the ECJ jurisprudence and reviewing a translation of this controversial Mazzol law, to revoke this extradition warrant. Saying that there is a current high probability that the extradition of the prosecuted person will be proved inadmissible, at least for the time being, due to the current developments following the judicial reform. With specific regard to particular legal issues, the court decided that on the basis of Article 47 of the EU Charter and different EU CJU cases like LM, like AK and others like Aragnosi, the Karlsruhe conducted this 2-stage test to assess indeed whether this person would have been guaranteed a right to fair trial in accordance with the established standards. When firstly assessing the objective presence of a threat to the rule of law in Poland, the HRC relied on previous judgments of domestic German courts to affirm that indeed a real risk of violation of the fundamental rights of fair trial was present. It went on explaining that in a second step it would have to examine specifically and precisely whether there were serious and factual grounds for believing that the individual at stake would be exposed to such danger. It specified that indeed in the AK and LM ruling, the national courts negated the effects of such danger on the person to be transferred. But after assessing the salient point of the Mazzol law, it found that this was not the case here and that the subjective element was fulfilled. The Mazzol law, for example, mandated disciplinary sanctions up to dismissal for obviously and grossly disregard of legal regulation, substantially impeding the function of an organ of justice, or perhaps question the effectiveness of the appointment of a judge or the constitutional mandate of an organ of the Republic of Poland. The High Regional Court, in light of paragraph 60 of LM and taking into consideration AK and Aragnosi, analyzed the situation and asked not only for further supplementary information on the status of the proceedings by the issuing judicial authority, but also more information on the sanctions in practice against the judges by the Ministry of Justice. This requested information was extremely specific and asked whether which judges have been sanctioned so far, what were the names, what legal remedy would have been available, and so on. But the fact is that it did not wait for the answers of the court because it realized that they would solve the LM dilemma by simply sending this catalog on questions. But it concluded that even in the event of positive answers, the legal assessment would not have been the same. This is because the court acknowledged that this individualized risk was present in casu, as even if there is no concern that the adjudicating body will find itself in conflict with general political guidelines or social view, there is the possibility that Polish judges face criminal proceedings on the basis of their evaluation of evidence. So since this judge at the ordinary court would have to evaluate this allegedly bribed witnesses' testimony, in case they would fear receiving this disciplinary sanction and they would not be independent, so that it would no longer be possible to talk about a fair trial. Thus, for the High Regional Court, the Mazzol law, in connection with the lack of independence, leads to serious doubts about the future independence of the police judiciary. And the High Regional Court concluded, leaving the door open, so saying that at the moment it does not suffice with a sufficient probability that the answers of the Polish authorities could allow for different legal assessment. it awaits for further development in Poland, and it awaits also for the ECJ case law. However, it concludes that in light of the publicly available information, the court cannot believe that at present the government will abandon its plan for judicial reform. This groundbreaking decision demonstrates indeed that the High Regional Court in Karlsruhe does not trust that the process against the Polish citizens will be conducted in line with the fundamental right to a fair trial. This is not an expression of distrust towards the Polish judges in particular, but rather towards the system built by the ruling majority at the moment. Clearly, the turning point, the straw that broke the camel's back, was the system of disciplinary liability mandated by the Basel Law. And this ruling is the proof of it. In light of the preliminary question by the Rechtsbank Amsterdam, and the answers given by the CJU and the LNP as presented by Professor Martufi, one wonders whether this approach is in line with the second phase of the LM test, and whether the German judge application of the ruling in caso indeed truly reflects the demands of the LM subjective tests element. Now, moving on to the Kammergericht Berlin judgment, it is essential to clarify this judgment in light of OGNP. In OGNP, it was about two surrenders of a Lithuanian national and a Romanian nationals, which were sought pursuant to European arrest warrant, issued by a public prosecutor in Lübeck and Zwickau, respectively. OGNP challenged the validity of this arrest warrant in front of a high-risk court, alleging that the German public prosecutor were not a judicial authority within the meaning of Article 6 of the Framework Decision 2002-584. On the basis that indeed under German law, the public prosecutor's office does not enjoy the autonomous or independent status of a court of law, but is subject to administrative hierarchy headed by the Minister of Justice, so that there is indeed a political involvement in the surrender proceedings of the German framework. Uncertain about the guarantees of independence of German public prosecutors, and after a back and forth, the Irish Supreme Court and the High Court respectively stayed the proceedings and asked the CJU whether the concept of issuing judicial authority included the public prosecutors of the member state at stake. Parallelly, it analyzed and published on the same day a judgment relating to the European arrest warrant issued by a Lithuanian prosecutor. On the one hand, while the Lithuanian prosecutor was considered to fall under this concept because she was free of any external influence, the German public prosecutor was found to fall outside the concept of issuing judicial authority. As primarily the dual level of protection, so the procedural and fundamental level of protection, fundamental rights that the person against whom an European arrest warrant has been issued must enjoy, namely when these rights at the national level, when the national decision is adopted and when a European arrest warrant is issued, were not sufficiently afforded. Indeed, this is because in accordance with German law, a national arrest warrant issued by a judge and the subsequent European arrest warrants is based on a national decision that has already been checked by the independent institution. However, the judicial authority must also assess the proportionality of the decision, which requires the authority to be fully independent. While the court in the OGNP case concluded that this proportionality assessment was lacking, in the same case before the Kammergericht Berlin, the German court almost grudgingly asked, but why us and not them? What is different with the Austrian prosecutor? And indeed sent a preliminary question to the CJU with regard to these proceedings relating to a European arrest warrant issued by an Austrian public prosecutor. The system of European arrest warrant was extremely similar, and the Berlin court asked for the compatibility with this system with the OGNP findings. and whether this indeed falls under the framework decision autonomous concept developed by the court. The court indeed reasoned that the CJU, the public prosecutor's office, which lacks this attribute of independence, may issue a European arrest warrant, provided that diverse guarantees of independence of this non-strictly judicial authority are in place. So differently than the German prosecutors, the Austrian prosecutors qualify as a judicial, as an issuing judicial authority. First of all, because under Austrian law, the issue of European arrest warrant is subject to its entirety to an objective and independent review by a court, which carries out a full review, as requested by the CJU, of the conditions for the issue of that arrest warrant and of its proportionality. Therefore, differently than in Germany, transmission of the European arrest warrant is only possible after the endorsement of by the court, whereas the German law provided a remedy ex officio a posteriori, and therefore the arrest warrant produced legal effect prior to transmission. Secondly, the court responsible for the endorsement of the European arrest warrant exercises its review independently and full knowledge of any instructions that may have been issued in advance, and adopts at the end of the review a decision that is independent of the decision that the public prosecutor's office. So while the German system included a mere confirmation, a mere legality check, here the Austrian had the possibility to actually analyze the case, having full access to the case, and therefore fulfill the requirement of objectivity and independence. Having access lastly to the entire criminal case, the situation was different, as the court could assess which were the instructions by the executive, and also analyze the conditions of issue and proportionality of those arrest warrants, being able to produce this autonomous decision that the CJU wanted. While this case did not impact the Austrian system very much, because it was indeed in line with European law, following OGNP and Parquet de Vion, the German court, the German system will have to be amended. So it's probable that this ruling will have a significant impact on German legislation and German policy, because according to the judgment, there will need to be a transformation of this European arrest warrant endorsement, changing the degree of autonomy and of the prosecution, and incorporating a judicial decision to the process, preceding this time the European arrest warrant and not rather a posteriori remedy. This would signify, of course, that the national German judiciary would take over more work in this regard. But it also signifies that the CJU will have its workload increased, because if now all member states will start asking the CJU to evaluate another member state institutions, the case law will undoubtedly become too much. So finally, the court grudgingly accepted the reasoning of the CJU, affirmed with reluctance that the Austrian public prosecutors, differently than in their case, fell under the concept of issuing judicial authority, and finally executed the European arrest warrant. Thank you for your attention.
Thank you very much, Carolina and Rebecca, for your presentation. Thank you for introducing another very important issue to our debate, so the notion of issuing national authority. And so thank you for giving us a comprehensive overview of the ECJ's case law in this regard, and also the follow-up at the national level. So it is very interesting to see the approach taken in this regard and the differences existing between this element and the LM test. So thank you, and thank you also for stressing again the duty of cooperation and how this duty was implemented by the Court of Karlsruhe, and this peculiar and very, I would say, bizarre way in which it applied such a duty. And the duty of cooperation emerged also in the next presentation. Our next speaker is Alessandra Favi, researcher of EU law at the University of Florence, who will give us an overview of the Italian case law, and in particular the Italian Supreme Court of Cassation case law with regard to the implementation of the LM judgment. So Alessandra, you have the floor.
Yes, can you see
me? Yes, you're presenting, yes.
Thank you. Good afternoon to everyone. So in my presentation, I will deal with 3 judgments where the Supreme Court of Cassation engaged with the application of the LM judgment of the Court of Justice. These judgments were delivered by the Supreme Court of Cassation Criminal Section between 2018 and 2020, and concerned the execution by the Italian authorities of several European arrest warrants issued by Polish authorities. These cases sketch the approach adopted so far by the Court of Cassation when dealing with the alleged violation of the fundamental right to a fair trial as enshrined in Article 47 of the Charter, on grounds of rule of law deficiencies in the issuing member state. The circumstances that gave rise to these judgments were very similar. Concerning the judgment of 2018, it originated from an appeal brought before the Supreme Court of Cassation for the annulment of the decision of the Court of Appeal of Bologna to execute an European arrest warrant against the applicant, a Polish citizen. One of the applicant's arguments was that the Court of Appeal disregarded the principle stated in the LM judgment of the Court of Justice. According to the applicant, the Court of Appeal did not apply the principle requiring the Italian authorities to refrain from executing the European arrest warrant when the person concerned is in danger of suffering a breach of his fundamental right to an independent court in the issuing member state. The Court of Cassation rejected the appeal as unfounded. At the outset of its reasoning, it summarized the main points of the LM judgment and found that the Court of Appeal of Bologna correctly applied EU law. Notably, the Court of Appeal correctly stated that the applicant was not able to show a clear link between the systemic problems in Poland and the existence of a concrete personal risk of violation of the right to an independent judge. He rather presented generic allegations without proving sufficient information. Furthermore, according to the Court of Cassation, the simple quotation of the LM judgment by the applicant was not sufficient to trigger the scrutiny by the National Court of the existence of the risk of a breach of the fundamental rights enshrined in Article 47 of the Charter in the issuing member state. In the second judgment, the judgment of 2019, concerned an appeal raised before the Court of Cassation by a Polish citizen for the annulment of the decision of the Court of Appeal of Milano to execute an European arrest warrant issued by Poland against the applicant. The applicant claimed that the Court of Appeal failed to recognize that if returned to Poland, he would risk a breach of his right to a fair trial due to the recent judicial reforms in that member state. Moreover, the applicant also claimed that the Court of Appeal failed to request additional information from the Polish authorities in order to assess the risk of breach of the right to a fair trial. The Supreme Court found the appeal inadmissible. Notably, it held that the Court of Appeal correctly applied the LM judgment of the Court of Justice, It then confirmed the findings of the Court of Appeal and stated that the executing judicial authority cannot refrain from executing an European arrest warrant solely on the basis of generic allegations concerning generalized deficiencies in the judicial system of the issuing member state. In principle, the executing authorities must verify whether there are substantial grounds for believing that the person will run a risk of breach of its fundamental right to a fair trial if returned to the issuing member state. In the case at stake, however, the applicant did not present any evidence to substantiate his claim, and therefore there was no need to request additional information to the Polish authorities. Thus, according to the Supreme Court, the Court of Appeal correctly applied the principles set out in the ELM judgment. Finally, in the judgment of 2020, the Supreme Court was called to rule on an appeal brought by a Polish citizen against the decision issued by the Court of Appeal of Venice and concerning the execution of an European arrest warrant issued by Polish authorities. For the first time, the Court of Cassation declared the appeal well-founded and annulled the judgment of the Court of Appeal of Venice, referring the case again to the lower court and requesting from it a more careful analysis of the rule of law situation in Poland. The applicant claimed the violation of Article 6 of the European Convention on Human Rights and Article 47 of the Charter. According to him, the Court of Appeal did not correctly apply the ELM judgment because it did not take into account the most recent judicial reforms in Poland and did not consider the relevant documents of the Venice Commission. Thus, the applicant concluded that the Court of Appeal failed to consider the risk of breach of his right to a fair trial if he were returned to Poland. The Court of Cassation started its reasoning by recalling the key findings of the ELM judgment and its previous case law, stressing that the executing state cannot refrain from executing an European arrest warrant solely on the basis of generic allegations of deficiencies in the judicial system of the issuing member state. The Court of Appeal had found that the applicant had not attached specific elements proving the risk of a breach of its fundamental right to a fair trial. However, unlike its previous judgments, the Court of Cassation stressed that after the ELM judgment, the situation in Poland had further deteriorated due to a series of judicial reforms. The Supreme Court recalled the judgments of the Court of Justice in the infringement proceedings brought by the Commission against Poland to stress the impairment of judicial independence. It then concluded that, in light of the new elements arising in Poland after the judgment of the Court of Appeal, the matter needed to be re-examined by that lower court. It also stressed that the applicant should attach specific and concrete information concerning the impact on its criminal proceedings of the recent legislation adopted in Poland. Some conclusion can then be drawn from the above-mentioned judgments, both as regards the role of the ELM judgment in the legal reasoning of the Court of Cassation and its concrete application in the cases brought before the Italian Supreme Court. Firstly, the Italian Supreme Court widely relies on the case law of the Court of Justice in order to assess the correctness of the reasoning of the Court of Appeal. It quotes entire paragraphs of the relevant rulings of the Court of Justice to underline the passages that a national court is called to undertake when confronted with the execution of an European arrest warrant issued by a member state with rule of law deficiencies. Secondly, we can see an evolution in the approach of the Supreme Court. In the judgments of 2018 and 2019, the Supreme Court did not put into question the Court of Appeal's analysis concerning the rule of law deficiencies in Poland. By contrast, in the judgment of 2020, the Supreme Court stressed that the rule of law situation in that member state has been worsening since the Court of Appeal adopted its decision. In this last judgment, it emerges a more careful analysis by the Italian court of the recent case law of the Court of Justice and of the judicial reforms undertaken by Poland. Thirdly, in its three judgments, the Supreme Court of Cassation did not consider necessary to send a preliminary reference to the Court of Justice. Notably, in its judgment of 2020, the Supreme Court of Cassation stressed that there was no need to raise questions for preliminary ruling, since it limited itself to assess whether EU law, as interpreted by the Court of Justice, was correctly interpreted and applied by the Court of Appeal. Finally, concerning the concrete application of the LM judgment in the cases at stake, the main difficulties seems to arise as regards the burden of proof and the role of national courts in collecting evidences relating to rule of law deficiencies in the issuing member state, as already mentioned by the previous presentation. First, we can infer from the judgment of 2020 that the rulings of the Court of Justice in the infringement procedures against Poland can be relevant in order to prove the generalized or systemic deficiencies in the issuing member state. Second, in the two judgments of 2018 and 2019, the Supreme Court stressed that the Court of Appeal correctly found that it is for the applicant to attach concrete circumstances justifying the link between the generalized deficiencies in the issuing member state and the individualized risk of breach of his right to an independent court. Only if the applicant has satisfied that burden of proof, the national authorities might be required to ask additional information to the issuing member state. Against this background, what seems to get lost is the spirit of cooperation between national authorities of different member states. Also, as already recorded by Professor Torres Perez, in the LM judgment, the Court of Justice attached great importance to the dialogue between national authorities as the only way to fill the lack of adequate information in the executing member state. That aspect seems to take a marginal role in the Italian judgments. This is a limit of the current approach of the Court of Cassation, also considering that in the LM judgment, the Court of Justice expressly stated that the correct assessment of the risk for the individual concerned might depend on any objective material concerning the conditions for protecting the guarantee of judicial independence that the issuing member state can provide. Thank you for your attention.
Thank you, Alessandra, for putting attention on this duty of cooperation, which actually the Court of Cassation, Italian Court of Cassation, interpreted in a very soft and questionable way, I would say. Thank you for emphasizing the link between the duty of cooperation and the burden of proof. And just let me stress that in this case law you have presented, the Court of Cassation said that only after the applicant has satisfied the burden of proof, the national authorities is required to ask additional information to the issuing member state. So it is an interpretation of the burden of proof on the one hand and on the duty of cooperation, which is a little bit questionable, I think, and I'm not sure it is in full compliance with the LM judgment, but we can discuss more about that. So now we move to the another member state and the Slovene case law, which will be presented by Mohor Fajdiga, who is a teaching assistant at the University of Ljubljana, and Mohor will give us an overview of a national case law which allows us to go beyond the strict implementation of the LM judgment, and he will introduce some new issues to our debate. So, Mohor, you have the floor.
Thank you very much, Marcella, for this kind introduction. Thank you very much also to Professor Lazzarini and to other organizers that invited me. I'm really honored to be the reporter for Slovenia. I'm also a member of a trial project, a member of University of Ljubljana, which is one of the partners. I'll try to be really very brief, because I know we're really running out of time. Actually, we're over the time. So first of all, let me just start with a few introductory remarks. I'm aware that this panel is actually devoted to implementation of the European Court of Justice's case law on the rule of law and the European arrest warrant. But unfortunately, Slovenia does not have much to offer. I found actually only 2 relevant cases that you can find published in the platform. So I won't go dig too much into them. I would just like to express that there is a common thread in both 2 cases. This is that first, there was a very poor job of the defense attorneys, which can be understood, especially if we take into account today's discussions, which prove that actually it's very unlikely that the person would actually be successful, that the European arrest warrant would not be executed. And the second common thread is that the judges actually also showed a lack of affinity to human rights. So in both cases, the attorneys provided only very bold and short allegations concerning systemic deficiencies. So the first prong of the test. So they didn't have like a strong case. They didn't put a lot of materials or I don't know, references to foreign judgments, the judgment of the ECJ or the European Court of Human Rights, to stop the transferal of their party to Poland and Hungary, respectively. So I think that the fact of this very poor job of the attorneys was actually the reason why also the court's job was not done properly. That's why they turned a blind eye to potential human rights violations. But nevertheless, the courts should not be excused by this, because they failed to provide a convincing de jure explanation why the human rights arguments that were put were actually rejected. The reasoning of the courts, moreover, showed that they were neither aware of the case law of the Luxembourg court, nor they did not know actually how this case law could be useful for determination of the cases at hand. Can you hear me still?
Okay, now yes.
Okay, yeah, I don't know. I lost my.
Yes, no, now it's working.
Okay, no, I don't have I don't see you. My screen is black, but I'll manage to do it. So yes, the courts didn't know how to use these cases. So I think going deeper into these 2 cases would not add too much to today's debate. So allow me rather just to raise 2 interesting issues that were raised in this second case. This was the case that concerned return of a Russian national of Chechen origin to Hungary. Now I got the screen back. Okay, thank you. The first issue is that the defense claimed that that this guy, this Chechen, who was also an asylum seeker, would be subjected to racial discrimination and would not benefit from fair trial, fair hearing, due to Hungary's terrible record of human rights violations against migrants. So the first question is, could this constitute a ground for non-execution of the European arrest warrant? And if not, could it at least be taken into account by the Slovene authorities when deciding whether to give precedence to European arrest warrant from Hungary or to the one from Austria? Because in this case, there were actually two conflicting European arrest warrants, one from Hungary and one from Austria. I won't discuss this issue. I just raise it to give you some food for thought. But the second issue is also interesting, is that this defendant, he lodged an application for asylum in Slovenia. So how does this fact impact the European arrest warrant proceedings? Can the application for asylum constitute a ground for non-execution of the European arrest warrant? Unfortunately, our courts didn't give us a good enough answer to this question, but I'll try to do it. So first of all, in IB case C306/09 from 2010, actually the Court of Justice in Luxembourg answered that the asylum claim cannot in itself justify non-execution of the European arrest warrant, but this case actually concerned a EU national, a Romanian national, who was sought by Romania, but the referring court was a Belgian court. So the question now is whether the case should be any different if we have a third country national. And this issue actually emerged in another European Court of Justice's case. This is the case of Gataeva and Gataeva C105/10. I can provide you with references if somebody is interested. But this case was actually not decided by the court because the issuing member state withdrew the arrest warrant. But the questions were nevertheless posed by the Finnish Supreme Court in this case. And the first question was how to reconcile on the one hand the obligation to execute the European arrest warrant with, on the other hand, the fact that the asylum seeker has the right to remain in the territory of the member state during his asylum procedure. And in fact, the Finnish court quotes Article 9, paragraph 2 of the procedural directive, which states that member states may deny, and this is important, may deny the right to remain of an asylum seeker, inter alia in the case of execution of an European arrest warrant. So the word may suggests that the executing authorities may execute or refuse to execute European arrest warrant on the ground that the asylum seeker has the right to remain in the territory of the member state. Well, however, I think that this interpretation is probably wrong, and why? Because there was the European Court of Justice explained in another case, C213/17, that when an asylum seeker is transferred under the European arrest warrant, this does not affect his right to have his asylum claim determined. It will be determined either by the issuing member state if it decides to become the responsible member state under the Dublin regulation, or it will be determined by the executing member state after the asylum seeker serves his sentence, which is imposed after the transfer, or when the criminal procedures are over. So we can infer from this judgment that actually an asylum claim as such cannot constitute a ground for non-execution of the arrest warrant, even if in cases when that concern third country nationals. But the question arises still, what about cases such as Gataev and Gataeva, which were of Chechen origin, and there was a clear risk that Lithuania, who was the executing authority, would extradite those two Chechens to Russia. What about these cases? Well, the framework decision actually provides an important safeguard against such refoulement to Russia. And in this Slovene case, to Russia, from Hungary to Russia. And this safeguard is Article 28, paragraph 4 of the framework decision, which says that a member state cannot extradite a person concerned without a consent of the executing member state. So, in case of Gataev and Gataeva, Lithuania could not extradite them without the consent of the Finnish authorities. But still, nevertheless, I think that there are some cases where one could argue that a European member state would just turn a blind eye to such potential human rights violations and would extradite a person to a third country. So what about those cases? Well, if we adopt the position of the European Court of Justice in Aranjuez and Calderaro, then in the LM, the two-pronged test would have to apply. But I think that in these cases, this two-pronged test would actually not be a good test. Why? Because if there are no systemic or generalized deficiencies, a surrender could nevertheless entail a real risk of inhuman or degrading treatment, and this is what the Gataev and Gataeva case shows. So in my opinion, in such cases, the European Court of Justice would have to abandon the two-pronged test, in the sense that both prongs work as sine qua non conditions for non-execution of the European arrest warrant. It would have to adopt an approach of the Strasbourg Court, where systemic deficiencies only serve to substantiate the real risk of individual human rights violations, and are not self-standing conditions for non-executions. I think it could look after its own jurisprudence concerning transfers under Dublin regulation. For example, in CK versus Slovenia, the European Court of Justice was willing to depart from the two-pronged test and recognized that even without systemic deficiencies, an individual risk for inhuman and degrading treatment may indeed constitute exceptional circumstances that justify non-transfer. So with this last thought, I would just like to conclude that in general, in my opinion, an asylum claim cannot justify non-execution, whereas there are, in some cases, exceptional circumstances, even without systemic deficiencies, that could on the basis of which a member state could reject an execution of the European arrest warrant. So with these thoughts that actually go a little bit to the next week's training, I would like to end my presentation and thank you for your attention.
Thank you very much more for building a bridge between today's and tomorrow's workshop and the workshop of next week. And indeed, actually, your presentation broadened our perspective, introducing new issues and underlining the interplay between the European arrest warrant procedures and the procedures for the recognition of asylum, of international protection. So you stress the interplay between two fields of the EU law, the interplay between them, but also the interplay that each of these fields have with the issue of mutual trust. And thank you for referring to the perspective to adopt a new approach with regard to the two-step test, and recalling the difference existing between the approach taken by the ECJ with regard the test in the European arrest warrant field and the different approach adopted by the ECJ with regard the test in the field of European asylum law. So thank you very much.